Thank you very much, Alberto. By the way, I want to commend for the speakers so far for their discipline, for staying completely within the allotted time. Our next speaker is going to speak to us about the Interamerican Convention Against Corruption, and he's very well qualified to do so because he helped to draft it, Carlos Manfroni. But I first have to say that in relation a little bit to what Alberto Perec just said about how we should do things not simply because they're required by law, some of us may be surprised at the fact that there is an Inter-American Convention Against Corruption, since it's obviously present in its absence in the region. It reminds me of something that happened to me 30 years ago. I was visiting Mexico City. The pollution was absolutely terrible in Mexico. You could practically cut it with a knife, cut the air, and a high-ranking Mexican government official friend of mine with a great sense of humor says, when we were having a dinner and somebody mentioned something about the pollution, he says, "No, there is no pollution in Mexico. We have some of the strongest laws against pollution in the world. So we can't possibly have pollution." Well, we have an Inter-American Convention Against Corruption, so therefore we're going to find out how we're going to be able to perhaps see the implementation of that convention so we can do something about corruption. So, Dr. Manfroni.
Thank you. Drafted the Inter-American Convention Against Corruption. Perhaps many of you will smile if I tell you that the negotiation of the convention was triggered by a Venezuelan proposal, certainly not by Venezuela ruled by Hugo Chavez or Nicolas Maduro, but by President Rafael Caldera in 1994. The convention was something completely new. It was the first international commitment that countries adopted to combat a problem that until then was only considered a domestic issue. But the convention was not innovative for being the first of its kind. The convention was the first document that, apart from a set of clauses of criminal cooperation, contained a chapter of preventive measures. Thus, the state parties agreed to legislate on a standard of conduct of public officers, mechanisms to enforce those standards of conduct, systems for registering the income, assets, or liability for persons who perform public functions, system on government procurement, systems for protecting people who report acts of corruption, oversight bodies for monitoring the system, mechanisms to encourage participation by civil society, and so on. Many of those measures were implemented by the state parties. For example, offices of government ethics and system for financial disclosures. In Argentina, the Office of Public Ethics, nowadays called Anti-Corruption Office, was created in 1997. Thanks to those measures, we are able to learn that the assets of the current president of Argentina, Cristina Kirchner, and her dead husband, Néstor Kirchner, grew by more than 1,000% during their administration. And this growth is only based on what they have declared. However, many judges in Argentina are not completely independent to investigate such a disproportionate growth, at least until the arrival of a new administration or the loss of power of the current one, which is starting to happen. Of course, there are always many exceptions, as the prosecutor Campagnoli, he was invited here. Anyway, the financial disclosure system is very useful, because at least we can learn about that information. Investigation will likely begin soon. Among the provisions of criminal law in the Convention, we can make a distinction between commitments of lawmaking and obligation of cooperating. Among the obligation of legislating, the state parties are forced to punish transnational bribery and illicit enrichment. Until then, only the United States had legislation on transnational bribery. The Inter-American Convention was the precedent for the OECD Convention on Transnational Bribery, which was signed in Paris the following year. Illicit enrichment is the failure of a public officer to justify the proportionate increase of its assets. We are not punishing the enrichment, but the lack of justification. An official who is only dedicated to public service and has no other income sources must reveal how she or he obtained the resources that exceed his or her salary. This provision is extremely useful for the Latin American countries. We don't have an FBI or other intelligence agency able to surprise a public officer at the time of receiving a bribe. On the other hand, it is very important to us that developed countries cooperate with us to find the ill-gotten fortunes. For this purpose, the Convention established revolutionary measures, such as the following. A state party shall not invoke ban secrecy against a request for information coming from another state. Acts of corruption must not be considered as a political offense, which means that corrupt leaders must be extradited. The state parties may share the confiscated properties for acts of corruption. The measures related to sharing confiscated properties should be extended to individuals. The clause quitem of the False Claim Act in the United States Code allows individuals to litigate in the courts in order to recover money that was improperly paid by the government. Those individuals receive a percentage of the money that they recovered. It would be great that the state parties approve similar legislation within the Convention framework. In particular, the article that requires measures to encourage the civil society participation. Some politicians of the opposition parties are proposing that kind of measures in Argentina. I believe that government bodies have a limited capacity to control corruption. The involvement of civil society is absolutely necessary. Besides the legal punishment, it is also necessary to recover the patrimony lost. This is an urgent priority in some countries, such as Argentina and Venezuela. We have reached a stage of extreme corruption, in a sense that such corruption has already become another concept. That corruption has changed its nature. Now we should be thinking about spoliation. The crime of spoliation is a concept that is being developed in some universities of the United States. The rulers are no longer satisfied with taking bribes, and they take over the entire business. Politicians make themselves owners of entire sectors of the economy. Right now, we have the case of the Vice President of Argentina who took over the company in charge of printing money. In the south of Argentina, the family of the former President Kirchner and his entourage bought expensive lands of the state at very low prices. And those cases are only two examples of the spoliation in Argentina. Thousands of millions of dollars were stolen and wasted in our countries. The slogan of the current president of Argentina, textually said by her, is, "We are going for everything." The sentence could not have been more descriptive. When they said everything, one can think that they might be referring to properties and institutions. Some centuries ago, Harrison said that corruption provokes power concentration. The preamble of the Convention was right when it expressed that corruption undermines the legitimacy of public institutions and strikes at society, moral order, and justice. In Nicaragua, several years ago, an independent candidate to the Managua City Hall, no liberal, neither Sandinist, was leading the polls. One day, he woke up with the surprise that he was no longer living in Managua. The authorities had run the limit and had left him out of the town. His house was no longer within the city borders. Therefore, he was not allowed to participate in the election. Corruption in some countries of Latin America is shameless. In Argentina, thousands of poor people receive a monthly salary under the condition that they don't take a job and that the government wins the election in the areas where they live. Thus, they have become a slave of the government. In my opinion, the Inter-American Convention Against Corruption should be updated to incorporate clauses addressing spoliation issues, as well as issues related to operations which distort the democratic system. In addition, we should work on a better mechanism to enforce the Convention. As usually happens in matters related to international law, the Convention has no mechanism to force the state parties to comply. It was the first international agreement against corruption, and we had to go step by step. On the other hand, we had assumed at that time that globalization itself would be strong enough to enforce the Convention. Those countries not ensuring transparency would not receive foreign investment. But that was true just for a number of countries that require immediate external investment. However, other countries rich in natural resources allow their politicians to continue with their corruption practices for several years. In addition, there are politicians who are absolutely indifferent to the prosperity of their countries. In 2000, state parties of the Organization of American States approved mechanism to regularly report the progress in implementing the Convention. But the experience proves that this mechanism, which is very important and necessary, was not enough. Both in Argentina and Venezuela, millions of people took the streets to protest against corruption, impunity, and distortion of democratic institutions. Those demonstrations show that our international mechanisms are still weak. Perhaps it's time to think about an Inter-American Court Against Corruption with similar powers to the Inter-American Court of Human Rights. Such a court could give protection to both the press and citizens who reveal acts of corruption. That court could act when domestic courts refuse to investigate important cases of corruption. That court could also act as a court of arbitration when there are allegations of corruption in big international tenders. It would be helpful to count on the U.S. and other developed countries to find our taxpayers' money disseminated in foreign accounts of corrupt public officers or their front men. In addition, it would be great if the U.S. continues to apply its executive order from Bush administration in 2005 that forces the revoking of the visa to public officials indicted of acts of corruption. They should learn that the world is too small nowadays. This would be the final stage in the development of anti-corruption international commitments, or maybe just the beginning. Thank you.